Yes, good morning.
Good morning, my lords. Would I appear together with my learned junior Adam Buchra on behalf of the British Medical Association and the defendant and respondent, the GMC, is represented by my learned friends Ivan Hare KC and Peter Mant KC.
Yes.
Your lordship should have, in terms of bundles, a core bundle, a supplementary bundle, a fresh evidence bundle and an authorities bundle, which may, I think, spill into a second volume.
Yeah, it does go into a second volume. Yeah, got all those.
In terms
and we've read a fair amount of the kit.
I'm very grateful, my lord. In terms of the fresh evidence, my proposal, subject obviously to any view to the contrary expressed by the court, is to make my primary submissions to refer, where appropriate, to material in the fresh evidence bundle, making it clear where I do so, and then to invite you to consider, as it were, the application itself, which will be developed by my learned junior at the end of the submissions, rather than take time at the outset of dealing with those matters. Because
it's not immediately clear to us whether there are any admissibility arguments. In which case, we'll look at the fresh evidence. I mean, we would anyway. The best way of fresh evidence is to look at it de bene esse, and then if there are points about admissibility, we'll deal with those in our judgments, rather than taking time in court with formal applications. And so if there are points on admissibility, those can be made as part of the submissions. But whilst obviously don't want to deprive your learned junior of his moment in the spotlight, I'm not sure we necessarily need a formal application. Let's see where we are on, as I say, whether there are disputes as to admissibility.
Certainly, my lords. And I understand from conversation with my learned friend, he had no objection to my proposals, which was to make the submissions in any event.
Well, I'm sorry, Mr. Bukhara, if that means that you might not get your moment in the sun, but I'm sure it would have been brilliant.
Thank you, my lord.
Yes, all right. The only other thing, as I say, we've read quite a bit. I think we have a lively appreciation of the issues. Given that the issues before us are narrower than those before the learned judge below, it does seem to us that a day and a half is quite generous. That's not to say, if we go over into tomorrow, that we'll be disgruntled, but I'm just saying I think a day is probably sufficient.
Well, my lords, I'll certainly bear that in mind. And if I take you to material that's not necessary for me to take you to, please feel free to tell me so, so that I don't waste the court's time. I'm certainly not proposing to pad my submissions out for the purpose of
I'm sure. Absolutely, I wasn't suggesting otherwise. Yeah, right. Okay.
So, my lords, the way I propose to just structure my submissions is to say a little about what we've described in our skeleton argument as the wider context, and I was proposing to take you to a handful of entries in the bundles, but it may be I can simply give you the page references in relation to that. Take you to the relevant parts of good medical practice itself, although I'm sure the court would have seen that, so again I can deal with that, I think, relatively quickly. Then deal with the legal framework and deal with each of the submissions in support of the grounds of appeal. So, my lords, dealing first of all then with what we've described as the question of context, this claim was made in a broader context of there being widespread substantial concerns about public interest, patient safety implications in relation to the role of associates. And I'm going to use the term associates rather than the more cumbersome physician associates and anaesthesia associates. And there were multiple aspects to those concerns, most of which do not bear on this appeal, but you will have seen reference in the materials referred to questions about should they be regulated, who should they be regulated by, should there be a scope of practice or ceiling of practice, and so on. But one common thread throughout those concerns, which is directly relevant to the issues in this appeal, is what we say is the limited understanding of the role of associates and the scope for confusion regarding their role, and in particular confusion regarding the distinction between associates on the one hand and doctors or medical practitioners on the other. you will have seen reference in our skeleton argument, paragraph 2, to those concerns having been expressed by a wide range of bodies. It's not a concern unique to the British Medical Association. It includes, for example, a number of the Royal Colleges, and concerns to have been raised by coroners in prevention of future death reports. You will also have seen that that led to the decision of the Secretary of State to ask Professor Leng to conduct a review and her subsequent report, which addresses a number of the broader concerns, but does not directly address the issue in this appeal. But if I can perhaps then just give you some references to where I say the most useful material is in relation to these issues of patient confusion and public uncertainty about the role of physician associates. And some of these references are in our skeleton argument, but not the specific pages or paragraphs. And I think it may be more helpful if I give you those specific pages rather than asking you to plough through long documents. So the first statement of Daniel McAlonan on behalf of the BMA in the supplemental bundle at pages 376 to 382 sets out a number of those concerns, and the passages I would suggest would be of most relevance are paragraphs 63 to 67, paragraphs 71 to 72, and paragraphs 75 to 76.
Could you just give us that first reference?
Yes, paragraphs 63 to 67.
Thank you.
So the statement begins on page 357, but it's pages 376 where that section begins. And I won't take time reading any of it out, but paragraph 63 to 66 deal with a study. You have an extract from the study itself in the supplemental bundle at page 45 about public confusion, public lack of understanding about the role of associates, confusion with the role of doctors. And then paragraph 71 to 72 of the witness statement, so pages 380 to 381, refer to two surveys by the BMA. The first was a survey of its members, and it's really the last bullet point in paragraph 71, which set out the view of respondents to the survey, 86% of whom felt public don't know the difference between associates and doctors. And then paragraph 72 refers to a separate survey of the public, again with findings, I think all of which are probably material to the issues we raised, set out there in paragraph 72. And then paragraphs 75 and 76 on page 382 deal with evidence, first of all, in paragraph 75, from NHS organisations themselves, conflating doctors and associates. And then paragraph 76, first bullet point, deals with a particular case of Emily Chesterton, who died after seeing what she thought was a doctor, but who was in fact an associate.
Sorry to interrupt.
Yes.
But the consultation, or survey, should I say, paragraph 71, is of its members and the public. Is there any breakdown as to the responses as to what percentage was from the members of the BMA and what percentage was from the public?
So paragraph 71, the findings in the bullet point are of its members. And then paragraph 72, it's a separate survey of 2009 members of the public.
I see. So that's a... I see.
So you have the figures there separately.
Okay, thank you.
And then, my Lord, just turning further in the statement, there is set out, beginning at page 384, under the heading Expressions of Concern by Other Organisations, references to the views and concerns of a range of interested bodies. I'm just going to flag up two of those, my Lords. The first is the bottom of page 387, subparagraph F, refers to a communication from the Academy of Medical Royal Colleges, setting out concern where the distinction between a medical practitioner and a MAP, that's another acronym for associates, is not immediately obvious to either patients or the wider healthcare team. And then over the page at subparagraph G, halfway down the page, you'll see reference to a position statement of the Royal College of Physicians, drawing out the clear differences in the education and training of doctors on the one hand and associates on the other, but then at the bottom of that page referring to the importance of patients and families, knowing the capability of those who meet and treat them. And then bottom of the next page, it's subparagraph H, it's a briefing from the Royal College of General Practitioners. And the last two paragraphs in italics on page 389 identify concerns of that Royal College about confusion amongst patients about the difference between doctors and associates. Similar to that, that's the material in Mr. McAlonan's statement. You have, I won't take you to it separately, but I'll just give you the reference. You have in the same bundle at page 45 behind tab 2 an extract from one of the pieces of research that his statement referred to. You then have, my lords, in the fresh evidence bundle, starting at page 160, the BMA submission to the Leng review, and much of it is not directly material to the issues with which you're concerned. But if I could just invite your lordship's attention to page 161. Under the heading Terminology on page 161, paragraphs 1 to 7 refer to a number of matters relating, again, to this potential for confusion or blurring of lines. Much of it is already set out in Mr. McAlonan's statement, but there's one additional matter in paragraph 2 on page 161. The last sentence refers to a further survey. That's a member survey rather than a public survey, with over 86% of 86% of over 14,000 respondents disagreeing or strongly disagreeing with the view that associates and doctors should be collectively known as medical professionals. Sticking with this bundle, the Royal College of Physicians also made a submission to the Leng review. That starts on page 67. There's just a couple of passages to show my lord.
Page?
Starts on page 67, and then my lords turn to page 69 in the document.
So that was the submissions to the Leng review. Now this is the Royal College response to.
No, this is the Royal College of Physicians. That was the BMA submission to the Leng review. Yeah. This is the Royal College of Physicians response to the Leng review.
Oh, I see. So this is also their submissions.
Yes,
yeah.
I apologise.
Okay, yeah.
And you'll see on page 69, under the heading "What is a PA?" you will see 3 paragraphs there which set out the importance of the difference between associates and doctors, and in our submission thus reinforces the importance of there being clarity and not confusion. And then if my lords turn to page 73, you will see a heading just over halfway down the page, concerns regarding PA expansion, and then the top of page 74 has a heading, clarity of roles. So this refers to a survey. This is now a survey of the Royal College of Physicians. The output of that survey being that the term physician associate is not well understood. This raises significant
concerns. That's way beyond the scope of this appeal.
Oh, my lord, it's the second and third sentence rather than that first sentence. It's the issue too about confusion and that.
Well, the physician association is not well understood. Well, that may be, but that's the description used in the order.
Yes.
This appeal is only concerned with 2 words: medical professionals.
My lord's absolutely right. It's the second and third sentences merely that I was proposing to refer to there, rather than the first.
Yeah.
And then, so my lord, those are some of the expressions of concern from a variety of organisations, including but not limited to the Appellant. In relation to the coronial material, you have 2 prevention of future death reports and responses from the Royal College of Physicians. I think probably just take this relatively quickly because you don't need to read the whole of the prevention of future death reports or their responses. So the report following the inquest into the death of Susan Pollitt is page 357 of the supplemental bundle, paragraph 4.
Sorry, page?
Page 357,
Thank you.
paragraph 4. And then the RCP's response to that is in the supplemental bundle at page 409. I don't think the paragraph numbers in the response. I don't think there are paragraph numbers in the response.
This was all material before the judge.
This was all material before the judge, yes. So it's page 409, first and third paragraphs that I draw attention to. And then the second prevention of future death report was the death of Pamela Marking. It's at pages 485 to 6 of the supplemental bundle, and it's paragraphs 1 to 2 of that coronial report. And then the Royal College of Physicians' response to that was not before the judge, so that's in the further evidence bundle because we didn't have it at the time. And the page reference for that is page 177, and the relevant parts are paragraphs 1 and 2 on page 178. So those are the coronial materials. And then we submit that there was a similar concerns raised in the course of the GMC's own consultations. So in the supplemental bundle, page 53, you will see a question in the GMC's own surveys. To what extent do you agree or disagree with the following statement? The associate role is well understood by patients. And then over the page, you have the summary table of responses, and you'll see that the disagree and strongly disagree were 33 and 30% approximately, as set out in that table. And then there's discussion, bottom of page 57, picking up on comments made in the course of the GMC's engagement exercise, which again raise issues over the question of understanding of the role and the scope for being mistaken as a doctor, and that's developed in the section discussion on pages 58 to 59. And then still within the GMC material, but just a single page, page 111. This is one of a number of documents generated during the GMC's engagement processes, first bullet point, patients frequently miss...
Sorry, which page?
I'm sorry, my lord, page 111.
Oh, sorry. 111.
Yeah.
Yeah.
Patients frequently misunderstand the roles. See survey results, only 7% agree that they do. And the roles, I should say, sorry, are roles of associates. And then indeed we see in the second bullet point a reference to many doctors also seeming to not understand the roles. So that's GMC material. And then finally, my lords, the Leng report, which is post-dated for hearing before the judge. So it wasn't before her, it's in the fresh evidence bundle. Again, most of it deals with matters that are outside the scope of this appeal. If my lords turn, however, to page 274 of the fresh evidence bundle, you will see towards the bottom of page 274, and this is, you have the whole of the Leng report, but so this is just part of it. Under the heading Identification, Professor Leng recording the main issues for patients related to clarity about who they were seeing, with many commenting on confusion between the PA and a doctor. And then, if my lords turn to page 306, still in the Leng report, point 4 on page 306, under the heading Full Trust from Patients and the Public. There cannot be full trust from patients and the public while issues about lack of clarity remain. And then a reference back to the earlier part of the report, referring to calls from the public with greater clarity. And then finally, page 318. This is in the recommendations section of Professor Leng's report under the heading General System-Wide Changes. Recommendation 15 was directed to the GMC, and it essentially picks up the other issue that we were arguing about in front of Mrs. Justice Lambert. And this is to say that there should be essentially a separate presentation of GMC materials. But the rationale is what I rely on. Lack of distinction between the role of the associate and the doctor has been central to the debates about the positioning and function of the roles, and regulation must not blur the line further. Those are the wider materials I wanted to refer to under that heading context. Turning then to good medical practice itself, and the terminology of medical professionals, first used by the GMC to encompass associates as well as doctors in a corporate strategy published in November 2020. That's it's in the supplemental bundle. You'll see an example of that at page 85, but I don't at the moment propose to take you to the detail of any of it. As a matter of fact, it had a corporate strategy that it published at that point in time in which it used that term. It was not, of course, at that point, actually the regulator for associates. However, that did lead to an exchange of correspondence between the BMA and the GMC. In the supplemental bundles at page 74 is the BMA email. I'm not proposing to take my lords to it, I'm just going to give you this reference.
Those are all set out in the judgment.
Those are, I think. And then the response by the GMC is at page 73 of the supplemental bundle, where they say, well, that we'll only use the phrase medical professionals where appropriate. Majority of our communications will be tailored individually. So that was, as it were, the first manifestation of the phrase being used, but as I say, in a corporate strategy rather than any more public-facing material. And at that point, the version of good medical practice which existed had been enforced, I think, since 2013 and was directed solely to doctors. There was some interim guidance drafted by the GMC, which was intended for associates only. That was, I think, never effectively utilised because of delays in regulation coming into force. But I just asked my lords to note That used the term healthcare professionals to describe associates, didn't use the term medical professionals, and that's at page 117 of the supplemental bundle, and I'm not proposing to take my looks to it. In August 2023 then, on the 22nd of August 2023, the GMC published its new version of Good Medical Practice. That would come into force at the end of January 2024. And that is where we see the use of the terminology medical professionals in this key piece of standard setting guidance for the first time. I'm not going to take time going to that version because, as you will know from the materials, after the issue of the judicial review claim but before the hearing before the judge, the GMC published an amended version on the 13th of December 2024. And so I'll simply take time with that version. It's in the core bundle. And it starts at page 289. And you'll see the dates from page 290.
Just for the note, the one at page 289, that is dated what?
The 13th of December 2024.
Right. So, yeah, so that was not the version that was the subject of the judicial review challenge.
It wasn't the version that was the subject of the judicial review challenge when the challenge was launched, but by essentially consensus of all the parties, it was treated as being the relevant version for the purposes of the hearing before Mrs. Justice Lambert.
Okay, so is this right? Page 263 of the core bundle is the version that was challenged.
Yes.
And then in December 2024, the relevant page is 293.
Starting on 293, yes.
Well, in terms of medical professionals.
Yes, the term is used at various stages throughout
Yes.
the guidance.
But but the description of medical professionals who is included
Is page 293.
is page 293.
And just to give my daughter a handful of further references, so you'll see, well, the term medical professional or medical professionals is then used throughout the guidance to encompass doctors and associates. And so we see that in relation to each of the sections of the guidance, so page 296.
Yeah, but that all follows on.
It does.
From page 293.
It does.
So the challenge turns on page 293.
It's certainly,
Because
that's the origin of the usage of it. Yeah, yes.
Yeah, and that's where the term is described.
Yes. I did just want to pick up on one of the further references, however, and you'll see the significance of this from the arguments about the statutory framework. What we see on page 297 under the heading Introduction, you will see there the reference to medical practice, and then the reference in the second paragraph to good medical professionals. And as you will have discerned, no doubt, from our skeleton arguments, we say that the idea of medical practice, medical practitioners, medical profession and medical professionals is inextricably interlinked. And so each of the domains, which is how this guidance is structured, then utilises the terminology of a medical professional. So we'll see that at page 301 for domain 2, 307 for domain 3, And 314.15 for domain 4. And my lords, our submission then is that the GMC's decision, and we say there was a specific decision, to characterise doctors and associates alike as medical professionals doesn't, for reasons I'll come on to in a moment, reflect the relevant legislation, and it exacerbates the already very real risk of confusion between the roles of associates and doctors, which in turn poses concerns for the public understanding of and confidence in the medical profession and the associate professions. And if I can just summarise the grounds, recognising as I do that there are elements of overlap between them. What we have termed ground 1 in our grounds of appeal and skeleton rests on what we say is the inconsistency, indeed conflict, with the statutory framework. And we've put that in 3 ways under the umbrella heading of ground 1. Ground 1A essentially is misdirection in law. We note that the GMC does not accept that there is any tension or conflict with the statutory provisions. If it's wrong about that, if it's promulgated guidance in the erroneous belief that it reflects and is consistent with the statutory provisions, we say the GMC has misdirected itself.
So that presupposes an inconsistency.
It does, yes.
Yeah. So,
Which is what,
I mean, that's one of the things about, just so that I'm clear, 1A, 1B, 1C.
absolutely.
They all presuppose the resolution of an issue before 1A, 1B, 1C, that it's inconsistent with the statutory framework. So actually there's effectively ground 1 simpliciter,
Yes.
which is it inconsistent? Because is this right? 1A, 1B and 1C all depend on it being inconsistent. Yes. Yeah, okay. Well, I thought that was the case, but let me just make a note.
And so 1A is, as we say, effectively is a misdirection in law type challenge. 1B is if the only way that one can view this inconsistency is through the prism of the Supreme Court's judgment in the case of A, we say, contrary to the judge's conclusion, this does fit within categories 1 or 3 in A. And then 1C, we say thirdly, that the promulgation by the GMC and the exercise of its statutory powers of guidance that in material respects runs counter to the statutory framework is neither Padfield compliant nor rational. So that's the first way, and ways in which the argument is put. Ground 2 does not...
And so sorry to interrupt you again. So if you're wrong on ground 1 simpliciter, then 1A, 1B, 1C doesn't arise.
Correct.
Yeah. Fine. Okay. And then ground 2.
And then ground 2 doesn't turn on statutory inconsistency. It's, as it were, pure conventional Hadfield and rationality arguments. It turns on an assessment of the defendant's decision-making process. The GMC's position accepted by the judge was that its reason, its aim for using this terminology was for readability and clarity, readability and accessibility, various phrases are used. And it said that that was an objective that was consistent with the pursuance of its statutory objectives and therefore both Padfield compliant and rational. We say in relation to ground 2 that there are 2 problems with that analysis. Firstly, it's belied by the evidence that was before the judge as to the GMC's actual reasons, and this is arguments that the judge doesn't really deal with in her judgment at all, but I can assure you were made. And then secondly, we say that position is now undermined by material that was not before the judge, but should have been in exercise of the GMC's duty of candour. And that's two of the documents in the fresh evidence bundle, which I'll come on to when we get to that stage of the argument, which renders, we say, nonsensical the claim that this can be for reasons of clarity and readability.
And so to that extent, or to what extent is ground 2 independent of ground 1?
It is independent of my submission.
Right.
It's entirely independent.
So you can be wrong about the inconsistency, say, but ground 2 still runs.
Yes.
Yeah, get that.
So Mills, can I turn then to the statutory framework? This is my Lord notes, that is the, as it were, the necessary precondition for the way in which the case is put in relation to ground 1. And we start with the Medical Act, which is in the authorities bundle, hopefully behind tab 2 at any event, hopefully at page 5.
I mean, by all means, take us through this. The judge identifies, I think, the relevant material. So obviously, we've been through that.
Yes.
So whilst it's always good to look at the core stuff, I'm not sure it's suggested that the judge missed anything out.
Nothing that would
of any significance.
nothing that would bear directly on the outcome of,
Fine,
of the arguments.
So we can take the judgment as a summary, but you're just showing us where we find the kit.
Exactly.
Yeah,
exactly.
fine.
So we have the overarching objective in section 1 of the Medical Act, pages 20 to 21 of the bundle. So the overarching objective of public protection with 3 objectives within that, so that's section 1.1a and 1.1b. And there you will see the reference to promotion and maintenance of public confidence in the medical profession and the promotion and maintenance of proper standards and conduct for members of that profession. So that's the first reference in the statutory framework to medical profession and members of the medical profession. Mm-hmm. What you will then see, and I won't take you through it section by section because nothing turns on the detail of the individual sections, is the terminology of medical practitioners. So we see that in from section 2 onwards, reference to what's required to be registered as a medical practitioner and the maintenance of a register of medical practitioners. And there are numerous such references, as I say, nothing is gained by me taking you through those. This part of the Act deals with the position largely in relation to registration. If you turn to then page 55, bottom of page 54, you'll see part 3A of the Act, which talks about licences to practice. And again, it's a licence to practice may be granted to a medical professional, that's section 29A.
Not medical professional.
Sorry, medical practitioner. And then...
I think it's agreed that medical professional is not a term we find in the 83
it's not.
Act.
No, what
it's
we see
medical
here,
practitioner and references to the medical profession.
and to members of that profession, precisely so.
Yeah.
Section 35, my lords, then is at page 83. And this is the statutory power under which good medical practice is issued, at least in relation to how it's directed at doctors. And there we see again the reference to the issuing of advice for members of the medical profession in section 35, halfway down page 83. And then if my lords turn on to page 124, you will see part 6 of the Act beginning. This is concerned with the privileges of registered practitioners, and it's section 49 at the bottom of page 126 that then deals with the offence of any person willfully and falsely pretending to be taking or using the name of, and then there are a number of specific protected titles, and then this or any name, title, addition or description implying that he's registered under any provision of this Act. And then there's a related offence in section 49A.
This is, this is how it's, excuse me, cited in the judgment. It's a slightly odd provision in it that it starts with 3 dots, but I see that that's as a result of words admitted by virtue of the European qualifications regulations. So I don't need to know what the words were, but it's strange to have a legislative provision which doesn't start with a full sentence.
Yes, my lord.
But anyway, that's section 49 as it currently is in force.
It is.
Yeah.
So those are the references to the terms medical profession, medical practitioner, and members of the medical profession in the Medical Act. Medical practitioner and medical profession are not defined in the Medical Act 1983. Medical practitioner is defined in the Health Act, and although I don't think anything turns on these provisions, just so that you see where they are in the bundle, the Health Act begins page 216. And at page 225, you will see section 60,
Yeah.
regulation of health professions, and section 60, subsection 1b, is the power to make an order in council regulating any other profession which appears to be concerned with the physical or mental health of individuals and to require regulation. And that's the power, the source power for the introduction of the Anaesthesia Associates and Physician Associates Order 2024. Yeah. And then, if my lords turn to page 239, you will see, and this is in Schedule Schedule 3 to the Health Act.
Sorry, what page was it?
Page 236.
Thank you.
I'm sorry, I said 239, 236. Paragraph 10. You'll see it says, halfway down in this schedule, medical practitioner means a registered medical practitioner as defined by Schedule 1 to the Interpretation Act. And you've got that at page 200, we're starting on page 239. With the relevant provision being at the top of page 249 in the Interpretation Act, Schedule 1.
249.
249. The top sentence on page 249.
Yeah.
So the only statutory definition of medical practitioner that we have is this, which refers back then to the requirements for registration and licence to practice in the Medical Act. And then we have the Anaesthesia Associates and Physician Associates Order 2024, which starts on page 262. I don't need to take you to any of the detail of how the associates are to be regulated, but if you turn to page 277, this is part of Schedule 1 of the order, and you will see their reference in paragraph 3, subparagraph 1, so the top of page 277, to the GMC's objectives and duties set out elsewhere, including in the Medical Act, and then the objectives of promoting and maintaining public confidence in proper professional standards and conduct for members of the Anaesthesia Associate and Physician Associate professions. So we have in the statutory framework 2 professions identified. We have the medical profession in the Medical Act, which plainly refers to what I would colloquially say is doctors. registered medical practitioners. And then we have the statutory language of the 2024 order, which refers to associates as members of the anaesthesia associate and physician associate professions. And so the submissions that we make in relation to the significance of the statutory framework, first of all, we say it's clear that both medical practitioners and the medical profession that's referred to in the Medical Act can only be referenced to medically qualified doctors and not any other form of healthcare professional. And if there were any doubt from the terms of the 1983 Act, that's made clear by the provisions of the Interpretation Act. We say the medical profession in the 1983 Act, therefore, must be references to those individuals who comprise that profession. There's no other profession to which the Medical Act can relate. And members of the medical profession, we say, therefore, can only mean medically qualified doctors. And medical professionals is a term which derives from the medical profession. It can't sensibly or logically be separated from it. We say Parliament in the 1983 Act and the 2024 order has chosen distinct and specific language to describe the respective professions. It's deliberately used the terminology of medical profession, and it's deliberately used the terminology of the associate professions. And it therefore draws essentially a circle around the medical profession and those who are members of that profession, who are medical professionals. There is no other sensible way of understanding that term. To call someone a medical professional clearly indicates that they are members of a medical profession, and the only medical profession under the statutory framework can be that which comprises doctors or registered medical practitioners. It could, of course, would of course have been open to Parliament to choose different terminology. And as you will have seen from the materials, there was a point in time at which it was thought that the Department of Health would use the terminology of medical professions within the statutory framework to encompass both doctors and associates. But Parliament did not do that. It did not amend the 1983 Act, and it chose in the 2024 order deliberately to use a different description of the profession to which physician associates and anaesthesia associates belong. So that we say is the problem in statutory terms and in terms of consistency with the statutory framework in the use of the phrase medical professionals, because it implies that associates are members of the medical profession when they are not, and when Parliament has said in clear terms in our submission that they are not. So that's the argument that it is, as it were, the precondition to ground one.
Yeah.
And if I turn then to how we put then the public law errors, which we say that gives rise to, how we characterise those. You will have seen from our skeleton reference to two authorities. They probably need no citation. One was Wednesbury, and the other, Secretary of State for the Home Department, ex parte Ola de Hinde, which talk about how within this context public law errors don't necessarily always neatly fit into a single characterisation, but the characterisations overlap. I'll give my lords the references in the authorities bundle without taking you to them. You have the passages in the skeleton, and I think it's a fairly self-evident proposition in any event.
This is the avoiding boxes point.
It is the avoiding boxes point, and I make it because in our submission that one of the areas that the learned judge below fell into was to become overly attached to the need to identify a specific box. And so...
it's usually quite helpful because it provides coherence.
It is, Mel.
So, I mean, that's why judges tend to like
Yes.
it, because, you know, administrative law is verging on the Wild West at times, and we do like to try and have a sheriff strolling down the street at least occasionally. It's probably not a very good analogy, but you know what I mean.
I do know what you mean, my lord. My lord, the point really is the judge said it had to be RA or nothing. And we say that was a wrong approach. And contrary to what is set out in her judgment, it was not position that we identified no other way of characterising, no other the public law error no box. We did identify misdirection of law. But leaving that aside, in any event, the references in our skeleton to the observations of Lord Donaldson in Ola de Hinde is Authorities Bundle, tab 11, page 481. And the relevant provision, extract from Lord Green's judgment in Wednesbury is tab 9, page 383. And so what we say under the heading of ground 1A is that the judge erred in saying that the only way the claim could be formulated is by reference to RA. And where she says that's an exhausted rubric, that was her phrase for assessment of the BMA's argument, we say that's just wrong. And that for the reasons I've given, if the GMC has used terminology that is in conflict with the terminology set out in the 1983 Act of the 2024 order, whilst believing it to be entirely in harmony with those provisions, that is perfectly capable of being characterised as a misdirection of law. But just to show you why she's wrong in any event in relation to RA, if we could turn to that, it's in the Authorities Bundle at tab 19. And I was just picking up, first of all, from the head note at point 1, so the second half of page 710 of the Authorities Bundle. You'll see there, this being a case where it said in broad terms there are 3 types of case where a policy might be found to be unlawful at common law by reason of what it said or omitted to say about the law when giving guidance for others. And that's important because that was the context with which their lordships were concerned in the A case. And if my lords turn to page 731 in the bundle, paragraph
I was noting something else. Page 7.
Page 731, paragraph 46 of the judgment. I'm going to go back to a couple of earlier questions. Here you will see in paragraph 46 the 3 categories set out, and you can completely ignore category 2. But it's the opening words that I draw attention to, echoing what's summarised in the head note. Cases where a policy may be found to be unlawful by reason of what it, so that's the policy, says or omits to say about the law when giving guidance for others. And then if my lords turn back to page 728, you will see in my submission further important context for what the issues that the Supreme Court were then giving guidance on. So if we pick it up halfway through paragraph 39 on page 728, between letters E and F. The court says there's often no obligation in public law for an authority to promulgate any policy. There's no obligation when it does for it to take the form of a detailed and comprehensive statement of the law in a particular area, equivalent to a textbook or the judgment of a court. And then paragraph 40 goes on to explain why the appropriate basis for intervention in such cases is therefore narrower. And then picking that up between G and H, public authorities might find themselves having to invest large sums on legal advice to produce textbook standard statements of the law. Also, if the tests were of the nature from which Mr. Southey contends, the courts would be drawn into reviewing and criticising the drafting of policies to an excessive degree. In effect, they'd have a revising role thrust upon them, requiring them to produce elaborate statements of the law to deal with hypothetical cases which might arise. And then, if my lords go back in the judgment to paragraph 2, you will see it, so page 713, you will see there's some broad observations in relation to policies, but again, the context there, policies which are directed at assisting officials to understand how to exercise discretionary powers. That's essentially what paragraph 2 says the case was about. And so in my submission, RA isn't an all singing, all dancing, this is the only way in which any piece of guidance or policy can ever be tested and analysed in public law terms decision. It's directed at the specific goal of policies which are designed to give guidance about the law and to provide a specific framework for lawful decision making.
So it's in relation to a policy design.
Policies which are intended to give guidance about the law and provide a specific legal framework for decision making, for lawful decision making by those to whom policy is directed.
Oh.
That, we say, is what RA was about. We are not concerned, and this is our primary submission, round 1B is our fallback submission, we are not concerned with such a policy in relation to good medical practice. But as we've referenced one further case in our skeleton argument, which I will just take you to briefly. It's a paragraph 24 of the authorities bundle, so it may be in the second volume.
Tab 24.
Tab 24, my lords,
Yeah.
I'm sorry. Page 905. And it's a case called CPH, a decision of Jonathan Moffat KC, sitting as a Deputy High Court Judge. And picking up the relevant section in the judgment at page 978.
Yeah.
You will see from paragraph 144 on page 978, the issue in that case was guidance which was designed to assist decision makers in a particular area, didn't mention a specific statutory duty. That was part of the basis for the challenge in 144. The Secretary of State's argument set out in 145, reliance upon A. And then the judge at paragraphs 146 onwards sets out a number of reasons why he doesn't accept that. The first reason in paragraph 146 is that those three categories in paragraph 46 of A are illustrative rather than, and this is my word, a straitjacket. But then at 147, this is the passage upon which we expressly rely, Jonathan Moffat KC refers to that part of the judgment where Lord Sales and Lord Burnett expressly stated they were concerned with the circumstances in which a policy would be unlawful as a result of what it does or does not say about the law. Therefore, on the face of it, they were concerned that policies would purport to set out for decision makers the law which applies to their decision-making function, And then he goes on to talk about the type of policy with which he was concerned, policies which merely give practical guidance to decision makers as to how they should exercise their functions. And then he goes on to deal with why, in any event, if RA is the rubric, and the case fell within it. And so, well, as we say that the judge was wrong to say the only way to assess the unlawfulness in the present case was by reference to RA and the categories in RA, because the unlawfulness here doesn't arise because we have a policy which is purporting to be a statement of the law, or which purports to provide a framework for statutory decision making, which is wrong. The difficulty, the unlawfulness here arises pure and simple because what is set out in good medical practice is, we say, fundamentally inconsistent with the statutory framework. And that's why we say it's much more aptly characterised as a misdirection in law. And so the judge was wrong to say you have to look and look only and be guided only by the categories in RA. If we are wrong about that, however, if RA does provide...
Sorry, just to pause
Yes.
there. So if you're right about that, what is the appropriate test, authority, line of cases that we would look at?
Well, there isn't a specific line of cases. Misdirection in law is a well-established ground for public law error. If a decision maker has got the law wrong, that provides a basis for the court to intervene. And here...
That will always depend on the facts.
Well,
So there's more to it than that, surely.
well, my lord, not in our submission. If in the context of what is a highly important area relating to patient safety and public trust and confidence in the profession, the General Medical Council adopts terminology which is inconsistent with the terminology in the statutory provisions and the statutory framework which gives it the power to issue that guidance, if it does that thinking that what it's doing is consistent with the Act, when as a matter of law it is not, it has misdirected itself in law, we say. And so that's the way we would put ground 1A. It's
Right. So that's a general statement. There's no authority or nothing you want us to look at in
There's
there.
no specific authority one way or another in our submission which casts any light or undermines that submission.
But if that were right, then would not the categories in R and A be irrelevant? You just say it's a misdirection in law.
Well, my lord, the categories in RA are concerned with the specific scenario where there is guidance to decision makers saying this is how you should exercise your discretion, and here is an articulation of the law in relation to that, and how you assess challenges to policies.
But why bother with any of that if it's just I'm just exploring
Yeah, I understand that, my lord.
what the alternative is. If it's just a misdirection in law, then that's that.
Well, my lord, because there may be all sorts of reasons why policy isn't straightforwardly inconsistent with a legal provision, but which might nonetheless be susceptible to review on an A basis. If it's purporting to give guidance to decision makers, which then omits critical areas for those decision makers to consider, then there is absolutely scope. For a challenge brought on an A basis that wouldn't fall neatly into being categorised as a misdirection of law.
Okay, sorry, I interrupted
No,
you
not
very
at all.
rudely. You were going to say if you were wrong about ground 1A, then
If the right way to look at it is through the categories in the case of RA, that's obviously contrary to my first submission,
Yeah.
as an alternative submission, if that is the exhaustive rubric, we say the judge was wrong to find that good medical practice doesn't fall within category 1, alternatively category 3, in paragraph 46 of RA. My lords,
It doesn't fit in with which category?
1 or 3.
Oh, so you say 1 or 3?
1 or 3.
Okay.
Predominantly 1, it's fair to say.
Yep.
My lords, we've noted in the skeleton, and I'll perhaps again give you the reference to the judgment of Mr. Justice Kavanagh in a case called Timpson. It's tab 22 of the authorities bundle, beginning on page 804. But it's just paragraph 143 at the bottom of page 842.
Sorry, this is tab 22, I've got that.
Tab 22,
Page
842. And it's paragraphs 142 and 143. And this is observations from Mr. Justice Linden in Cardona, and then from Mr. Justice Kavanagh in Timpson, about how to approach paragraph 46 of REA, and whether these are rigid categorisations or are illustrations. And you will see paragraphs 142 and 143 in my respectful submission speak for themselves, that paragraph 46 categories in RA are useful illustrations of broad categories of case, but not necessarily something which is intended to give a rigid definition. But in any event...
Sorry, I thought we were under ground 1B, which is where you say you fit within.
My lords, forgive me, there are two similar but slightly distinct points. In underground 1A, we argue that the category of public law error that could be applicable is wider than RA.
Yeah, I get that.
Underground B, we say, yes, alternatively, we fall within 1A, but when you're looking at, we fall within RA, but when you're looking at RA, you don't read what the Supreme Court said as a statutory definition of the precise parameters that have to be met.
So it's sort of, you fit within it, but you have to look at those categories fluidly.
Yes, precisely the same. It's a much better way of putting it than
Well, I don't know about that, but I understand that.
and so category 1
Yeah.
in RA is where the policy includes a positive statement of law which is wrong and will induce a person who follows the policy to breach their legal duty in some way.
Can we just find it so I can see it in the... Yes, where the policy includes a positive statement of law which is wrong and which will induce a person who follows the policy to breach their legal duty in some way.
Yes.
Yeah.
And we say that the problem with the use of titles in good medical practice is that it both fails to adhere to what we say is the clear statutory distinction between the medical profession and the associate professions. And then it effectively would authorise or approve a breach of section 49 of the 1983 Act. Because it's plain from good medical practice, an associate would be entitled to refer to themselves as a medical professional. And if you're referring to yourself as a medical professional, indeed to being a member of a medical profession, it would be nonsense to suggest otherwise. But if an associate, a non-doctor, is describing themselves as a medical professional, they are, we say, using a name, title, addition or description, implying that they are either registered under the Act or recognised as a practitioner in medicine.
Which particular words of section 49 do you say are offended?
It's the last part of first main description, my lord. So it is. It's an offence for anyone with obviously the requisite mens rea, either to use certain titles, that's not what I rely on, because those are specific titles.
Yeah.
Or to use any name, title, addition or description implying that he is registered under any provision of this Act, or that he is recognised by law as, and then you can skip over physician, surgeon, etc., a practitioner in medicine. And so we say the use of medical professionals gives carte blanche to associates to say, I am a medical professional. Clearly they must be entitled to say that because good medical practice describes them in those terms. I'm a member of a medical profession. But that's where the interrelationship between medical profession and medical practitioner in the 1983 Act is so fundamental, and why we say there is a conflict between the guidance and the statutory framework. So it effectively, the guidance, by using that terminology, permits a breach of Section 49. Well, we've set out in our skeleton argument a number of more specific criticism of the judge's reasoning, which I don't think I probably need to go through, because I don't think I have anything to add to what is in the skeleton argument. But if my lords just turn to our skeleton, please. Sorry, I have it separately, but it's somewhere in the core bundle.
Yep. Paragraphs.
The submission I've just made effectively is paragraphs 14 onwards. Sorry, not 14, paragraph 17 onwards.
Yeah.
But in that's 17 to 23, in paragraph 24 of our skeleton argument, we've set out some specific criticisms of the judge's reasoning. Unless my lords want me to develop any of those, I would invite you to essentially take those as written, because I don't have anything to say in addition on those specific criticisms to what is set out in the skeleton argument.
And then in the alternative, as you indicated, paragraph 25, you say you fall into 3.
Yes, and what we say, and this is really where the observations in Cardona and Timpson are important, for a policy to purport to set out a full account of the legal position, by that we say it's not limited to a policy which says, here is everything you need to know about the legal regulation of doctors or associates. We say, what does it purport to say about the legal issue in play? And what it says about the legal issue in play is that associates can describe themselves as medical professionals. And we say, for the reasons I've already mapped out, that presents a misleading account of the legal position. Well, that's the argument in relation to RA, that is the applicable guidance.
Yep.
Ground 1C then identifies 2 alternative public law boxes into which we say the claim could be put, again under this overall umbrella of inconsistency or conflict with the statutory framework. We say it would be the position is unlawful either on the basis of Wednesbury irrationality or on the basis of offending against the Padfield principle. I'm sure I don't need to take my lords to Padfield, but it's in the bundle at tab 10, the authorities bundle, with the head note at page 389 and then page 422 with the reference to discretion being conferred with the intention it should be used to promote the policy and objectives of the Act. In many Padfield challenges, the true difficulty is the search to identify what are the policy and objectives of the Act. Here we have them set out explicitly in statutory terms in section 1(1)(a) and 1(1)(b) of the 1983 Act. That's the public protection objective in its three manifestations. The way we put the Hadfield challenge in this specific context is that if the GMC is using titles contrary to the 1983 Act and the 2024 order, by implying that associates are members of the medical profession, we say the GMC cannot be regarded as exercising or seeking to exercise its statutory functions to promote the purpose of the 1983 Act. Because if you're issuing guidance which is wrong in law about the titles that are used, that must, we say, run counter to and frustrate the objectives in section 1(1)(a) and (b) of protecting the public, maintaining public confidence in the profession, and promoting and maintaining public confidence indeed in the associate professions too. Alternatively, we say it's irrational in the Wednesbury sense to issue guidance which uses titles that are in conflict with the very statutory framework which governs the exercise of the power to issue that guidance. Those are the submissions on ground 1 and the statutory framework.
Yeah. Okay, well look, if we're coming to ground 2, we'll have a 5-minute pause, understanding that ground 2 is a completely standalone ground made up of the two elements that you say, the material that was before the judge and then secondly the material that wasn't. Yeah, okay, so we'll come back according to that clock just past 5 to 12. Thank you very much.
Just let everyone know the live stream will still be open.
No, I mean. Yes, thank you.
So, my lords, turning then to ground 2, which arises, as I say, independent of ground 1, we say the judge erred in rejecting the freestanding Hadfield and irrationality grounds for the challenge. In paragraph 101 of her judgment, she characterised the BMA submissions in terms of Hadfield as a complaint that the GMC hadn't achieved the statutory objective. That, she just made clear, was not our argument, and is not our argument today. We don't say that's the appropriate measure for assessing the case. When the court looks at the judge's reasoning from really paragraphs 101 onwards, and when she looks at the issues of Hadfield and then irrationality, her reasoning focuses almost entirely on the other aspect of the challenge that was before her, which was, in a sentence, the failure to issue completely separate sets of guidance, directed very specifically at associates.
Yeah, the unitary guidance.
Unitary guidance.
Yeah.
And the vast bulk of her reasoning in relation to Hadfield and irrationality is directed at that. She says very little about the position relating to the medical professions issue. There's a sentence, I think, at the end, or two sentences at the end of paragraph 102 that deal with it. and again at the end of paragraph 112. But what she doesn't do in her judgment at all, although this material was before her and although arguments were made on it, is deal with what we say the actual evidence was about the GMC's decision-making process regarding its adoption of the term medical professionals. And so, my lords, for these purposes, if I can take you first of all to the material that was before the judge in the supplemental bundle, starting on page 189.
Hang on, just.
$189 to begin with.
No.
And you'll see this is part of material starting on page 181, a survey for organisations and individuals. And then on page 189...
so this is the public...
It's part
public consultation
yes.
By the GMC on core guidance on professional standards.
Yes, on essentially what should and shouldn't be in good medical practice.
Yeah.
And if we turn to page 189, about 2/3 of the way down the page, it's the last paragraph under the heading Style and Application. There's just two sentences. We've adopted the term medical professionals to describe all the professional groups we regulate. That doesn't then contain an explanation as to why. But then it says this is also the term that will be used in the legislation to bring PAs and AAs into regulation. So the one reason they're given, although it's the use of the also might suggest there's another, but the other's not articulated, is that the GMC thinks medical professionals is going to be the statutory term in the new legislation. And then if your lordships turn to page 244, this extract starts at page 243, and it's part of the GMC's analysis of the response to consultation. And at page 244, you have the heading, the term medical professionals. And then it says 73 respondents commented on the use of the term medical professionals, which we explained we'd adopted to refer to all those we regulate.
The judge refers to this.
She refers to some parts of this,
She
yes.
refers to this particular bit, I mean, in her judgment, because I remember the figures of 73 and 35.
Yes. What we say, my lords, is lacking from the judgment, and I can find the relevant paragraph numbers, is an analysis of the way our case was put on this basis.
I understand.
And a rejection of that.
Yeah, okay.
I'm not suggesting she doesn't refer to some of the underlying material.
Okay, so we're looking at what they say about the term medical professionals. Yeah?
Yes, so it's just the first two sentences. Again, this is the GMC saying, we explained this term would be used in the legislation. So that's the GMC again identifying its understanding that medical professionals is going to be the term in what was anticipated to be further legislation authorising them to regulate associates. And then if my lords turn to page 246, you'll see these are the minutes of a particular group set up by the GMC that was looking at a number of issues relating to the associate professions. Bottom of page 248, paragraph 11, someone picks up on a description in a communication strategy document, and then the response is from someone on behalf of the GMC, explained that we use individual profession names in our communications wherever possible and only employ collective terms when needed. We understand that medical professionals will be the term used to describe our three registrant groups in the GMC's future legislation, and it's also one we use in the GMC's corporate strategy. So there again we have the central reference to the understanding that it's the term derived from legislation. And then page 255, and this is another GMC document. Picking it up at the bottom of page 255, this is a document discussing the response to the consultation. And then we see this passage in paragraph 29 at the bottom of page 255. Perhaps inevitably, the majority comments focused on the one issue that is not in our gift to change, the use of the term medical professionals to describe doctors, PAs and AAs. And then, before I make a submission on that, on the next page, paragraph 34, we'll continue to use the term medical professional because it is DHSC's preferred collective name for the GMC's 3 registrant groups, and so is likely to feature in future legislation relating to the GMC. But absolutely plain that the reason the GMC was using medical professionals was because it wanted to match what it understood the legislation would use by way of terminology. And indeed, it regarded itself as not in a position to change that, not in our gift to change.
Yep.
Which can only be a reference to an understanding that something's going to be enshrined in legislation. And so, what actually happened is that the legislation didn't change the terminology of medical professionals and introduce it as a term of art in statutory language to encompass the associate professions and the medical profession. Instead, the 1983 Act remained absolutely unamended in its reference to the medical profession and members of that profession. And the 2024 order did not use the terminology of medical profession or medical professionals, but the terminology of anaesthesia associate and physician associate professions. And so there are 2 issues, we say, in relation to that. The first is the GMC's decision-making as a matter of fact was tied to the statutory language. It wanted to have terminology that reflected what it thought the legislation was going to say. But because the legislation never changed and the 2024 order went down a different route, the GMC never revisited its initial reason. Had it done so, the logic of its position could only be, well, we should now use terminology that reflects the legislation. Or we're going to continue to use medical professionals because there's a whole range of other good reasons why we should do so. But we don't see any of that in my submission in any form of contemporaneous decision-making material. And so tying that then to both, well, first of all, that Padfield argument, if I can invite my Lord's attention to the authorities bundle, I'm not showing you Padfield, I promise, tab 13. Page 533, there's a Court of Appeal decision in a case called Braintree Ex Parte Calls. And the relevant passage in the judgment of Lord Justice Laws is at page 542. Picking it up in the paragraph about a third of the way down the page, which begins, "Now it would in my judgment." If your lordships look a few lines down, you'll see he refers to the leading case being Padfield. And then he says this: "The rule is not that the exercise of the power is only to be condemned if it is incapable of promoting the Act's policy. Rather, the question always is, What was the decision maker's purpose in the instant case? And was it calculated to promote the policy of the Act? And so that means that the court has to focus upon what the actual objective was. The objective, as we've seen, was plainly to match what the GMC thought was going to be in the legislation that never was. But if the objective was to match the legislation, then that should, once the position became clear that the Department of Health was not going to use that terminology, should have militated against then promulgating and publishing a version of good medical practice which stuck to what the GMC had previously thought was going to be the new statutory position. So that's the focus upon what the actual purpose was. Is it calculated to promote the policy of the Act? Well, the overarching objective in section 11A, 11B, public protection, public confidence, public trust. We've seen that nowhere in the GMC's contemporaneous decision-making on this issue, because its sole reason was to do what it thought the Department of Health was going to do in its new legislation. And so it failed ever to ask itself the question, if we use these phrases, this terminology, these titles, which are not in the statutes, and so we're not compelled to use them, will that promote the objectives of the Act, or does it have the potential to undermine them because of the issues about confusion and lack of certainty about the roles and responsibilities of doctors and associates? My Lords, we say that's a straightforward Padfield challenge when you look at what the actual reasoning of the GMC was. It's also a straightforward Wednesbury challenge in the sense, and I'm talking about as it were, the wider concept of Wednesbury rather than pure perversity. And if my Lords turn in the authorities bundle to the next tab, the Law Society and Lord Chancellor case, divisional court decision, and there's a very useful summary on page 571, paragraph 98, between F and H.
571.
571, my Lord.
Yeah.
Para 98 deals with the initial classic formulation of Wednesbury, the perversity element of it, between E and F. And then between F and H deals with the second aspect of irrationality, concerned with the process by which the decision was reached. Is there a flaw in the reasoning with substantial reliance placed on an irrelevant consideration? Was there a serious logical or methodological error, etc.? And we say we have here a classic logical gap or critical error or failure to take into account a relevant consideration, because when it became apparent to the GMC that the legislation was not going to be as it thought it should be, it should have realised that fundamentally undermined the sole, or at least principal basis upon which it adopted that terminology in the first place. And of course, its belief that it was not in its gift to change the term is simply wrong. And so that's the material before the judge.
Yeah.
Can I then take you to documents not before the judge?
Oh.
So if the court turns to the fresh evidence bundle. And if we start on page 13, please. So this is another internal GMC meeting, 11th June 2024. Certainly well before the hearing before Lambert J. This is material, I should say, that the BMA has only received because of other litigation rather than was never disclosed by the GMC in this case. Top of page 14, paragraph 5 of these minutes, you will see reference there to a multi-professional terminology guide, and that's an internal guide and not a published one published to the world. Any use of the collective term medical professionals requires permission, say the GMC. And so, having seen that, we asked for a copy of the terminology guide and received 2. The first starts on the next page. So there's a June version of the guide and then a December 2024 version of the guide, so both predating the hearing before the judge. If my lords turn to page 22, so this is in the June 2024 terminology guide. And you'll see, first of all, reference to medical practitioner, top of the page.
Yeah.
And it says avoid using this term as it's not easy to understand for members of the public. Then we have the term multi-professional, and then it says, say physician associates and anaesthesia associates separately, don't roll them together. These are 2 different professions with 2 different entry routes and training styles. Well, just an observation, if that's the case as between physician associates and anaesthesia associates, it's all the more the case as between those professions on the one hand and the medical profession on the other.
That's a unitary guidance point.
My lords, it's not a point that goes directly to the use of medical professionals, but it's a point, I say, that goes to the question of clarity and the scope for confusion, which underpins ground 2. And then top of the next page, it says, don't say that PAs and AAs practice medicine. In any event, that's the June guide. And then if you turn to page 27, I think this is still the June guide, I think. You will see, page 28, references to various uses of the term medical schools, medical students, primary medical qualification, UK medical graduates. So medical is there identified as being the term for doctors. If you look at the top left-hand corner of the page, that's that column. So a recognition of the close association between the concept of being medical and being a doctor. And then, if my lords turn to the December guidance, the position becomes clearer. So that starts on page 33. If you turn to page 37, bottom of the page, paragraph 1, you see the same point I've just referred to about not rolling together the 2 associate professions because they're 2 different professions. And that's point 1 at the bottom of page 37. Yeah. And then if you turn to page 39, point 6, this is part of the core principles section of the guidance. Follow our advice when using the term medical. And then there's a reference to a term medical associate professions, which has somewhat fallen by the wayside as a use of term. There can be confusion about when and where to use the term medical, and we want to avoid that. Don't use the word medical to refer to or include PAs and AAs when talking about education or practice, e.g., and then you have a whole list there set out. Use with caution the word medical when talking about our registrants or our role as a regulator. We may occasionally refer to our whole population of registrants as medical professionals, but prefer to say doctors, PAs and AAs. And then, bottom of page 42, so the last 2 paragraphs on 42, so only use medical practitioners when referring to doctors. You should avoid using this term altogether as it's not easy to understand for members of the public. It's always preferable to say doctors if that's who you mean. Over the page, picking it up, top of the page, but about 3 lines down, in your communications you should be clear about the different professions we regulate. only refer to practitioners if very necessary. Where possible, please say doctors, PAs and AAs, or just doctors if that's what you mean. The medical profession is singular. We've historically used it to mean doctors. Well, the Act uses it to mean doctors. Now we regulate two professions. Therefore, when talking about our work generally, we can no longer use the singular term, the medical profession. Don't use the term, the medical profession, when referring to PAs and AAs. You can still use it if necessary when referring only to doctors, but it's always preferable to simply say doctors if that's what you mean. And then the assertion the medical profession is not the same as medical professionals. It refers to doctors' concerns, or some doctors' concerns about the use of the collective term. It says if you need to describe who we regulate, you must always list each profession in full and in this order: doctors, physician associates and anaesthesia associates. At bottom of the page, don't use the term medical professionals in information for patients on social media, in media quotes, on presentation slides or in blogs. For staff needing to directly quote good medical practice where the term medical professionals is used, this is okay. The above may seem confusing, but we want teams to take time to consider their writing and always think about what is clearest to the reader. And then the next guide then refers to what had been the misconception about what was going to be in the legislation, that it was going to be medical professions, and that changed. Whilst that guide obviously still retains the reference to medical professionals in good medical practice, I asked my lords to view that as against what the GMC said to the judge and what the judge found was the justification for using medical professionals in good medical practice. It was to promote clarity, readability, and accessibility. And we say that to suggest that that is what is achieved by the use of medical professionals, when one sees what the GMC is saying internally here about the scope of the confusion, the fact that medical profession cannot encompass associates, the fact that the term medical should be avoided when being attached to various aspects of associates' education and practice. And then the instruction, don't use medical professionals to patients' social media, presentation slides and in blogs, i.e. in public-facing documents. We say completely undermines the key reason that the GMC put before the judge and the judge found for saying this was both rational and consistent with the GMC's statutory objectives in section 1 of the Act. Indeed, we'd suggest that document, which ought to have been disclosed in discharge of the GMC's duty of candour, would have cast a very different complexion upon the reliability and credibility of the GMC's arguments on that issue. So, my lord, those are the submissions on ground 2, my lords.
Yeah.
That leaves the issue of extension of time, ground 3.
Yeah.
Where we say the judge erred. So we were in the slightly unusual position that she granted permission, but then refused the extension of time.
And that's the extension of time to serve the claim form?
Yeah, well, extension of time to issue the claim form, yes.
Yeah.
So there is, in our respectful submission, an obvious tension between those positions. What she could have said, and if this is the way my lords want to view the position, then legally that would be perfectly impeccable reasoning. She could have said, because of the lapse of time or delay, I will refuse to grant relief. But that isn't, in fact, the way in which she dealt with it. In any event, we say she...
Yeah, no, she could have done that, but I mean, it's really only the sequence of it that is slightly unusual. I mean, you could say, a purist would say, the purist part of me would say, that actually this is the first issue, because if you're not entitled to an extension of time, then the claim fails.
Yes.
And so with my procedural hat on, I would say, well, there we are, that's the first issue. So, I mean, I'm not sure I agree that there's a tension. I mean, it's a slightly odd way that it's come out because it's dealt with at the end rather than at the beginning. But at all events,
Yes.
the point is that you need to appeal on the extension of time point, whether that comes first or last. That's what you need, and that's ground 3.
Yeah. Yes. I mean, what I would say is, and the reference for this is a judgment called Inclusion Housing, which is in the Authorities Bundle at tab 17, page 666. What that says is ordinarily the grant of permission precludes a defendant from contending that the claim should be dismissed on the ground of delay, but doesn't preclude a defendant from arguing that relief should be refused. Similarly, it's not. There is a very real tension between granting permission and saying you can't have an extension of time. But having made that submission, because I would on any view accept that it could be relevant to the grant of relief. I'll deal with the substance of the points. The judgment in Maharaj, which I'm sure the court, indeed Lord Justice Coulson will be familiar with, it's at tab 15. And it's paragraph 38 on page 600. It sets out, I think, uncontroversially, the factors that can be considered.
Hold on, let me just put away the fresh evidence. Tab 15.
So tab 15, and the relevant passage is on page 600. Paragraph 38. And so just picking it up in the second sentence, here it is important to emphasise that the statutory test is not one of good reason for delay, but the broader test of good reason for extending time. This will be likely to bring in many considerations beyond those relevant to an objectively good reason for the delay, including importance of the issues, prospects of success, presence or absence of prejudice or detriment to good administration, and the public interest. And there were multiple public interest cases that were before the judge.
Mm-hmm.
And so we say the judge, first of all, fell into error in finding that the grounds to make the claim arose in April 2023. It's paragraph 121, I think, of the judgment. That was the date contended for by the GMC on the basis that that's when the GMC approved good medical practice for publication. But that was a draft that was being considered. And I'll just give my lords the page references in relation to that. You'll see that in the statement of Mr. Swindles on behalf of the GMC at paragraph 85, page 442 of the supplemental bundle, in which he talks about the GMC Council being presented with a near final draft. And then page 284 of the bundle is a paper which notes that we say that the document was not yet completely finalised. Mm-hmm. But in any event, that was an internal process within the GMC. The good medical practice itself was sent to the BMA for the first time in its final form on the 15th of August 2023, prior to publication on the 22nd of August 2023.
Yeah.
And so we say that would be the relevant date from when time should start to be calculated. The second point we would note in relation to timing is that it was, in fact, a document that wouldn't come into force until January for doctors, and wouldn't actually, at that point, bite on associates at all, because the GMC was not yet the statutory regulator for associates. And the second error in the judge's judgment, we say it is in paragraph 122, where she says there's no explanation for the delay in commencing proceedings. Leaving aside the question that the true question is there good reason for extending time rather than good reason for delay? In fact, the BMA had explained in its witness statements, in its pleadings, and in its written and oral submissions, the position. I'm going to give my lords the references, and then I'll just summarise the main points rather than taking my lords through each part of the bundle.
Okay.
But it was addressed in the first witness statement of Mr. McAlonan at paragraphs 84 to 88.
And the
Supplemental bundle 394 to 5.
supplemental bundle
Pages
394.
394 to 5.
394 to 395?
Yes.
Yeah.
It was addressed in the third witness statement of Mr. McAlonan in paragraphs 7 to 14 and 30 to 31. And that's supplemental bundle pages 473 to 475. It was then addressed in the BMA's statement of facts and grounds, as you would expect, paragraphs 88 to 92, core bundle, pages 254 to 257. It was addressed in the BMA's reply to the GMC's summary grounds of resistance, and that's paragraphs 14 to 15, supplemental bundle, page 407. And it was addressed in the BMA's skeleton argument before the judge at paragraphs 97 to 102, core bundle, pages 147 to 149. Amongst the points made there was that at the point in time at which good medical practice was published in the form that was the challenged, that was prior to, some months prior to, the making of the Anaesthesia Associates and Physician Associates order. So the guidance was published in August 2023 to come into force in January 2024 in relation to doctors. But at that point, the GMC was not the statutory regulator of associates. And there was a whole range of lobbying in Parliament, and issues raised in Parliament, genuine debate about whether the GMC should be the statutory regulator or not. That involved the BMA, but it involved a number of others. If Parliament had not made the order, there would have been no claim to bring, because the GMC would have had to amend good medical practice, because it was not going to be the regulator of associates. And so we say it would have been premature for the BMA to bring the claim in advance of the making of the statutory order on the 13th of March 2024. And once it was confirmed that the GMC was going to be the regulator, there was then, on the 13th of March, publication of a consultation by the GMC on draft rules, standards and guidance, which I think began on the 26th of March 2024. And it was, in our respectful submission, again, reasonable for the BMA, or a good reason for extending time, to await the publication of those proposed consultation materials, because that might have indicated GMC taking a different regulatory course now that it was the actual regulator. And then the third broad point made in all the materials that I've given you the references for is that the issue, the BMA reflects the interests of its members, and the issues in relation to associates, and in particular the terminology used in relation to associates, and then the views being expressed by other organisations and other bodies. And then, and again this is all detailed in the statements, the publication by NHS bodies of materials which showed that even NHS bodies were misunderstanding what an associate was and conflating it with a doctor. Those were effectively increasing and growing concerns. which, combined with the fact that GMC had now stuck with its course and become the regulator in March, led then to the filing of the claim on the 3rd of July. But those are all factors and reasons that fall to be assessed. I'm not submitting that they could only point in one direction, but they are all matters that needed to be considered by the judge. And we said they were not properly considered. Third point in relation to the judge's approach, unsurprisingly, perhaps, but her refusal to extend time was inevitably shaped by her conclusions on the grounds of challenge. And she says that in terms of paragraph 122. And so she said, well, I found that none of this is unlawful, therefore, essentially, why bother with extending time? But if we're right on any of the grounds of challenge, the merits of the claim are a relevant factor to be taken into account.
So the judge did that. She just said there weren't any merits.
Yes.
So she was acting in accordance with the guidance in Maharaj.
On that particular point, my lord, yes.
Yeah, but so the point is simply if you're right on grounds 1 and 2,
That factor.
then that becomes a factor the other way.
Exactly, my lord.
Of course.
Exactly, my lord. Yes.
Yeah, well,
yes. Not an error of the judge in that respect, my lord.
I was going to say it's not an error of the judge. You
On that
say
point.
it's a consequence if you're right about the appeal. Yeah.
But then fourthly, where we say the judge was wrong, was to conclude that the public interest and the patient safety issues did not themselves provide a sufficient basis, combined with all the other matters that I've referred to say either extend time or grant relief, if she were looking at it from that perspective. Because there was ample material before her and there is material before you that shows this common thread of concern about confusion in relation to the roles, a lack of clarity on the distinctions between the roles. And we say that this claim was an issue that went to the heart of those concerns and was a matter and is a matter of significant public interest. And finally, my lords, on the question of delay extension of time, it was of course the case that the guidance good medical practice had been amended in December 2024. And it was that version of good medical practice that was treated as the version that the judge should assess and base her conclusions on. And so this wasn't a challenge to simply to a document, a piece of guidance produced a year or more previously. In essence, we were looking at the version that had been produced in amended form in December 2024. And that very fact of them having produced an amended version in our submission undermines any reliance there could be upon questions of detriment or prejudice to good administration or otherwise through the making of an extension of time.
That's because it was the December 2024 version you were looking at.
Yes.
Although it was the August 2023 version that was the subject of the challenge. That was the point we made before.
Yes.
So again, it's the procedural Wild West in one sense, because you should have a challenge in relation to a document, i.e. the August 2023 document.
Well,
And I mean, one of the things, and you know this 100 times better than me, in public law, documents, policies, guidance, whatever, change all the time. And so that's why you need to focus on what it is that's being challenged. I mean, your point here is simply that in the end, the argument before the judge focused on the December 2024 document.
my lords, that's absolutely right. And that was, I'm not sure whether I've got all the documents in the core bundle, but that was effectively the common position before the court. It was not suggested that the court should look at the unamended version of good medical practice, because that would have been a sterile exercise. It was also, I think, a common and commonsensical acceptance that what we had in December 2024 was not something that was so radically altered that the only way you could sensibly do it in terms of procedural integrity would be to withdraw the challenge and reissue. My lords, unless I can assist further, those of my...
Can I just ask a question around this last point about delay, and interrupt you whilst you're take us through the points. Your first, I think, possibly your second point, was around her comment in paragraph 122 that there's been no explanation for the delay, and you told us that there had been indeed explanation given. When she refused permission to appeal, she found there was no good explanation for the delay. That's page 85. How should we reconcile those two slightly different points?
Well, no, her reasons for refusing permission are not her judgment, and it's the judgment that's appealed against, not what's said subsequently about it.
Well, hang on a minute. There's authority that says that. There's authority that says reasons for refusing permission need to be treated by the Court of Appeal as part of the judgment.
In that case, if that's right...
As I covered myself once brilliantly when I was at first instance by spotting I'd forgotten a point and dealt with that in the reasons for refusing permission to appeal. So I do know that that's the law, happily for me. Yes, what's the basic answer to my lord's question?
Well, look, the basic answer is we've no idea what she made of the reasons and from the judgment, and there is no discussion of them. There is a single throwaway sentence in the judgment which omits the adjective good. If the court wishes to infer, reading that sentence together with the reasons for refusing permission, that what she was actually saying is that there's no good reason, there is still no assessment of what the actual factual position was or what the evidence was.
No, and we are looking on your revised, you say she was wrong to pick the date in April, 27th of April as the start date. But I think you are accepting that she should pick the 22nd of August. Am I right?
Well,
she wouldn't be wrong to.
She wouldn't be wrong to pick that as the time from which, the date from which time would start running.
So there was a period then between August 23 and July 20.
Yes, and what we then say is you then have to look at what we were saying about what was going on during that period, in particular the fact that the GMC was not the regulator, which narrows then the period for which an extension of time is sought to a much shorter period, essentially between March and beginning of July.
And I haven't read the judgment with my eye focused on that particular point, but do you say that she hasn't dealt with that in the earlier section of the judgment, where she does talk about the actions or inactions of the BMA at various points? I think she refers to the inconsistent responses of the BMA. Does she deal with this particular period in that early part of the judgment?
I'll be correct if I'm wrong. I don't think she does. What she deals with the extent to which the BMA was or wasn't party to some of them, the earlier, much earlier meetings.
Yes.
And she deals with the fact that there was, someone who was also a member of the BMA not raising any objection through a meeting, and she deals with the email exchange about the corporate strategy and
she describes it as patchy in terms of the BMA reaction.
Yeah. But I mean that's all before the relevant date in my respect.
That's what I had in mind, and I'm just wondering whether or not you say if there's anything in that earlier month. If you wanted to.
I'm just going to check. I don't think she dealt with the specific points that we were making in relation to why we said there was good reason to extend time, having regard, amongst other matters, to what it was the BMA was and wasn't doing at that kind of key period, 23 to 24.
Thank you very much. That was very clear. Mr. Hare, your 15 minutes of fame start now.
I can't promise to finish in 15 minutes.
No,
And that's not because I'm trying to hold Mr. Booker's limelight or anything else or his moment in the spotlight.
So far, I have to say, everything has been an absolute model of efficiency. So not even we expect you to finish in 15 minutes.
Thank you very much.
Yes.
Perhaps what I can say, though, is first of all introduce the structure of my submissions. The general point behind those is this, that there's a risk, we say, that this case becomes bogged down in questions of taxonomy about precisely which of the public law grounds is being advanced on the basis of which authority of the Supreme Court or otherwise. And rather that, of course, the focus of that has been around the case of the Crown on the application of A. And so what I would propose to do in the first part of my submissions is to advance a series of propositions, 5 propositions, which we say provide a better guide than focusing on those questions of classification of policy changes and whether we're within a Roman 1 or a Roman 3. If I'm successful in that, we say, the case falls away, because what that does is remove the legal element of the challenge. The legal element of the challenge, being that this is a judicial review brought on grounds of illegality and Padfield and so on, and irrationality, means the claim falls away. But I will then deal briefly and separately with what's said in relation to Padfield and irrationality, and thirdly I'll say something about delay. And if I may, following the pattern of my learned friend, I'll say something about the fresh evidence at the end. Excuse me.
Yeah.
Well, if I could start then with those 5 points.
Yeah.
The reason that taxonomy has become so important, we say, is because, of course, of the criticisms of the learned judge below for regarding herself as effectively required, my learned friend used the term straitjacket, but required to approach ground 1 of the BMA's challenge through the lens, if I can put it in that slightly more neutral way, of that case in the Supreme Court of the Crown on the application of A versus the Secretary of State for the Home Department. We say it's not necessary to approach it that way, and indeed we invite the court not to approach it in that way. Here are my 5 points. The first one is, we accept, of course, that the grounds of judicial review are not hermetically sealed, and that it's legitimate to advance a successful judicial review challenge which draws on, or which, as it were, may be classified in different ways. That's what John Donaldson was saying in the O'Ladderhine case to which you've been referred, and of course we agree with that. It's what's said in a very different context in Wednesbury, but in any event, we accept the point. I'm afraid that's very much the shortest of the 5 points.
Yeah.
The second point is that we also accept that this case, the BMA's case, is not on all fours with the case of A in the Supreme Court. My learned friend has shown you a little of what that case was in fact about. Guidance issued about the child sex offender disclosure scheme. My learned friend invited the court to read the head note which sets out what that was. And it's fair to say that the case of A, and indeed the case of the Crown on the application of BF, Eritrea, which is the case which immediately follows it, both in the law reports and in the authorities bundle, is directed towards guidance, general guidance, about policies which are intended to guide the exercise of legal powers. So most of those policies and most of the matters identified by Lord Sales and Lord Burnett of Malden in terms of, in both of those judgments, in terms of what the benefits are of public authorities formulating policies, relate to the benefits that follow if they make the exercise of legal discretion more structured, more consistent, more transparent to those who can read the policy and therefore direct their application in relation to it, to the specific concerns that the policy identifies. That's not what good medical practice is. But the fact that good medical practice is different, very different, is a point in the GMC's favour. Can I explain the three most obvious ways in which good medical practice is different from the sort of policies that were being discussed by the Supreme Court in the A case? First of all, it is manifestly not directed at a public authority seeking to provide guidance about the exercise of that public authority's legal powers. Good medical practice, this was an important part of the discussion below, and as I understand it, was accepted by the BMA below and certainly accepted by the judge. Good medical practice is not even, I mean, it's available on the GMC's website, but it's not directed at patients, it's directed at registrants, at medical professionals, whether they're doctors or now members of the associate profession. Now, of course, that doesn't necessarily mean that you can't approach it by reference to the authorities which relate to policies about the exercise of discretions, because the Gillett case, which I'm going to spend a little bit of time on if I may, it'll be after the short adjournment, but the Gillett case was about policy guidance which was directed towards health authorities, but in fact spoke mostly about decisions by doctors. So I'm not saying that that first point is one that means that the policy type analysis is not appropriate, but it's relevant to it, and it's an important distinction. The second distinction is the crucial one. Good medical practice is not about doctors or other medical professionals' legal obligations. It's about their ethical duties. And if I could just remind the court, please, of that by inviting the court to turn back to the core bundle, page 293, where we have the December 24 version of Good Medical Practice. This is the first page, as it were, of the substance of good medical practice.
Yeah.
My Lord Justice Coulson took my own friend to it earlier on. Under the heading, What is Good Medical Practice? It's a useful place to look, perhaps. Good medical practice sets out the principles, values, and standards of professional behaviour expected of all doctors, physician associates, and anaesthesia associates registered with us. If the court then skips a paragraph, the third paragraph says, good medical practice is an ethical framework. It's the first line of the third paragraph. And then under the heading, how to use good medical practice, the second paragraph begins, after saying what it is, as it were, says, but it isn't a set of rules. And that's extremely important, we say, when we come on to a learned friend's attempt to identify what she describes as a misdirection in law, or a misdirection of law. The question that hangs over these 5 points I'm making is, where is the law in my learned friend's submissions? Now, of course, it's not the case that one can say, or that good medical practice attempts to say, that a doctor's or other medical professionals' ethical duties are entirely divorced from the law. Of course not. For example, if one takes the example of physician associates, and there's guidance in good medical practice on prescribing, of course, physician associates cannot legally prescribe. And so, of course, there can be an overlap between there's an overlap in relation to obtaining consent, in relation to the law of tort, of course. So there could be a number of areas in which there's an overlap, of course, between ethical guidance and the law. But the point is that good medical practice is not intending to set out the legal obligations of medical professionals. And we see that particularly clearly. This is moving on to the, as it were, the third point. Because the references...
Your third proposition?
No, sorry. The third sub-point in relation to why is good medical practice different from the
Oh, I see.
policies that are discussed in A.
Yeah.
So, yeah. Shall I recap them, my lord? Or were they not clear? The first two were, the first one was it's not directed to a public authority about the exercise of legal
Yeah.
powers. The second is it's an ethical code,
Yeah.
not a legal code. The third one I'm moving on to is what's an issue in this case, that is to say the use a handful of times by the GMC of the term medical professionals isn't even in the part of good medical practice which relates to the ethical duties of doctors or other medical professionals. And that's clear from the references my learned friend gave the court about where the term appears. My Lord Justice Coulson made the point on 293. Unsurprisingly, that's the first reference, it being the first paragraph, where it uses the term and defines what they mean by it. We use the term medical professionals to describe all our registrants who we address directly as you throughout the guidance. There's then another reference to medical professionals obviously there. But then if you go through the guidance under the domains that to which my learned friend referred, you'll see that in each of those domains, the reference to medical professionals is in the introduction, not the number. Take, for example, page 297. Domain knowledge, skills and development.
Yeah.
Medical practice is a lifelong journey. Good medical professionals are competent, keep their knowledge up, etc. That's not one of the ethical. What that means is then explained in the numbered paragraphs of good medical practice. Yeah. And as this court's probably aware, if you're charged with a form of professional misconduct which involves a breach of good medical practice, it won't refer to the introductory section, it will refer to the paragraphs that create specific obligations. So that's the third point, is that not only is it not directed to a public authority dealing with the exercise of its statutory discretion or common law discretion, not only is it ethics rather than duty, the bit that's challenged, the only bit that's challenged, the use of the term medical professionals, isn't even in the normative part of good medical practice. And indeed, to the extent that my learned friend says, I think she went as far as to say GMC's use of the term medical professionals gives PAs and AAs carte blanche to describe themselves as medical professionals. That's flatly contradicted when you look at good medical practice itself, and indeed good medical practice as a whole. I'll come back to this. Paragraph 82 of which says you have to be clear about who you are and you have to introduce yourself to patients, as well as all the other provisions about you have to act within your competence, you have to be supervised in appropriate cases if you're an associate, and so on. So there's nothing in relation to the use of the term medical professionals which would encourage a physician associate or an anaesthesia associate to refer to themselves as a medical professional. If they did that, they may well be acting contrary to specific obligations in good medical practice to identify themselves to patients accurately. So, Lord, that is the second of my 5 points. I see it's 1 o'clock.
Yeah.
Maybe, I don't know if that's a good point.
No, that's a very good place to pause. Thank you very much. We'll come back at 2 o'clock.